Hello and welcome to today's episode of You and the Law. Please subscribe to our channel. On today's episode, we will be looking at the legal elements of an offense. Criminal law is based on the maxim, Actus non facit reum nisi mens sit re. This Latin maxim means that an act does not make a person guilty, unless it is done with criminal intention. Therefore, a person should not be convicted and punished in proceedings of a criminal nature, unless it could be proved that he is guilty of an act with guilty knowledge or mind. This is why the prosecution in all criminal cases must prove the case beyond reasonable doubt. As a general rule, for a person to be guilty of an offense, two elements must be present. 1. The outward conduct or the guilty act which is prohibited by law, known as the actus reus. 2. The state of mind, which is the guilty mind, known as the mens rea.
So, for an act to constitute a crime, there must be a guilty mind, plus the physical manifestation of the act constituting the offense?
Exactly. These two elements must come together to constitute a crime. Actus reus is taken to be the wrongful deed that comprises the physical elements of any crime, while mens rea is the criminal intent, or guilty mind of the accused. For the prosecution to establish a criminal act against an accused person, it must go beyond establishing the commission of the act, and establish that the accused person had the correct legal criminal mind of committing the act. The two must coexist, whether explicitly or by necessary implication.
Is it possible for an act to be committed without a guilty mind?
Of course. In that case, we will be talking of accident, insanity, provocation or self-defense. In these cases, it will be obvious that the accused did not intend the consequences of the act. Different offenses have different actus reus. For example, the actus reus of murder is the killing, in stealing, it is the taking, while in rape, it is the unlawful intercourse. Mens rea varies from one crime to another. This state of mind may be referred to as intention, negligence, recklessness, knowledge or carelessness. The court must bear in mind that unless a statute, clearly, or by necessary implication, rules out mens rea as a constitute act of a crime, the court should not find a man guilty of an offense, unless he has a guilty mind. Let us now follow our case study, to find out how the actus reus and mens rea played out in court. The marriage between Mustafa Usman and his wife produced 6 children. The family all lived somewhere in Sokoto State, Nigeria. One fateful day, Mustafa told his wife he was relocating back to Lokoja. He was a native of Aloma, in Kogi State, Nigeria. He moved to Lokoja, while his wife and children continued to live in Sokoto. Few months after his stay in Lokoja, he got a new job and also a new wife. His first wife continued to live in Sokoto with her children. Few years later, her first son Umar came to her and said,
"Mummy, I want to go and stay with my father."
You want to abandon me like your father? For God's sake, you are my first child. Who will take care of me? How will I survive?
I need money for my trade. I can only take care of you when I start something meaningful. I am sure he will raise some money for me. Please let me go.
It appears you have made up your mind. There is no problem. Please take care of yourself.
Umar traveled to Kogi to stay with his father. By the end of the 3rd year, something happened.
Father, I want to discuss something with you. I am all ears. Go on. Please, I need that money I told you about. I want to start doing something with my life. I have told you repeatedly that I do not have money. Be patient. When money comes, I will give you. This is all you keep saying. I am here wasting away. You do not care about my mother. You do not care about us. Is that fair? Are you not tired of treating us poorly?
After this encounter with his father, Umar began to plan for his father. On the 10th of November 2007, Umar went to his father and requested for a cutlass to cut the grass around the house. As the father entered the room to produce the cutlass, Umar followed him inside the room. He locked the door, collected the cutlass from his father, and cut him repeatedly in the most vulnerable part of his body, until his father died. On seeing that his father had died, Umar opened the door, washed the cutlass and ran away from the house. The next day, he tried to sneak into the house. Unknown to him, the youths were already keeping vigil. That was how he was caught. He was taken to the police station. He admitted to killing his father and volunteered a confessional statement. On the 15th day of July 2008, he was arraigned at the High Court on a charge of culpable homicide, contrary to Section 220 and punishable under Section 221A of the Penal Code. Call the first case.
Umar Mustafa Usman versus the State. 2018, 15 NWLR, Part 1642, 320. The accused person is in court, my lord.
Any legal representation?
With respect to this honorable court, I am Bassie West. My appearance is for the state. With profound respect to this honorable court, I am Jude Johnson, announcing appearance for the accused person.
The charge was read to the accused person. He pleaded guilty to the charge. However, since it was a capital offense, the court entered a plea of not guilty for him. Open your case, counsel. Call your first witness.
Very well, my lord. Please tell the court who you are. My name is Felix Daniel. I am the police officer who investigated the case. Tell the court the outcome of your investigation. When we got the report of the death of the deceased, we immediately visited the crime scene. We saw the lifeless body of the deceased. We took pictures of it and commenced investigation.
The photos and negatives of the corpse were admitted in evidence and marked Exhibit B and C.
The accused was not seen when we got there. The youths of the community brought him to the police station the next day. He volunteered a statement where he admitted that he killed his father.
The statement was admitted in evidence and marked Exhibit D. In the said statement, Umar stated that he came to Lakoya to establish his business. He also stated that his father was a bad man, as he did not take care of his mother and siblings.
That will be all for this witness, my lord.
Prosecution called other witnesses and closed its case. Open your case, defense counsel.
Very well, my lord. Umar, tell the court what happened on the day that your father died.
I told my father to give me a cutlass. I wanted to help him cut the grass in the compound. When I saw the cutlass, I did not know what came over me and I cut him.
What do you mean, when you said you did not know what came over you?
Something possessed me. I did not know what I was doing.
That will be all for the witness, my lord.
Any cross-examination?
Very well, my lord. Umar, can you tell the court why you came to Lakoya to stay with your father?
It was only my mother that raised me and my siblings. I came to Lakoya purposely to collect money for my trade. My father was a bad man. He did not take care of us.
Did anybody send you to kill your father?
No, sir. I killed him voluntarily.
That will be all for the witness, my lord.
After the defense closed its case, parties addressed the court. The prosecution urged the court to convict the accused person, as he had the requisite mens rea that culminated into the offense of culpable homicide. All the actions he took, before and after the death of his father, showed that he planned to kill him. The prosecution argued. The defense counsel argued that Umar had no requisite mens rea to kill his father, on the ground that he suffered disease of the mind shortly before he killed his father. After the address of counsel, on Wednesday, the 25th day of March 2009, the court delivered its judgment. I have carefully followed the arguments canvassed by parties. I agree with the prosecution that the accused had the requisite mens rea to commit the said offense. I therefore find him guilty of culpable homicide and sentence him to death by hanging. Dissatisfied with the judgment of the court, he appealed to the Court of Appeal. His appeal was dismissed. He appealed further to the Supreme Court. One of the issues before the Supreme Court was whether the ingredients of the offense of culpable homicide punishable with death was proved beyond reasonable doubt. Both parties agreed that the deceased died, and that it was the act of the appellant that caused the death of the deceased. However, the area of discord was whether the act that led to the death of the deceased was done with the intention of causing death, and whether the accused knew, or had reason to know, that death would be the probable, and not only, a likely consequence of his act. After the argument of counsel, the Supreme Court delivered its judgment.
Except in offenses of absolute liability, the law is settled beyond any argument that for an accused person to be liable for his act, it must be established that he intended to cause such act, or that he knew, or had reason to know, that death would be the probable consequence of his act. This is encapsulated in the Latin maxim, Actus non facit reum nisi sit re. This simply means that an act does not make a person guilty unless it is done with a criminal intention. It follows, therefore, that guilty intent, or knowledge, is an element of the offense of culpable homicide, punishable with death. Consequently, if the prosecution fails to prove such intention, the accused must be set free. In the instant case, the question is whether the prosecution established that the appellant intended to kill his father. It is common knowledge that it is impossible to know a man's intention until it is manifested. A man's intention can only be established by circumstances and facts leading to the commission of the crime for which he is charged. It is very difficult to know what a man intends without resorting to chains of events that culminated into the act complained of. It is only God, and perhaps the devil, whose powers are beyond human comprehension, that is capable of knowing a man's intention. The law presumes that a man intends the natural and probable consequences of his acts. The test to be applied in this circumstances is the objective test, namely, the test of what a reasonable man would contemplate as the probable result of his act. The appellant in this case went into the room where his father was, and dealt him blows on his head and face, both vital parts of his body, with a cutlass. The deceased shouted for help, and because the appellant had locked the door, nobody was able to access the room in order to assist the deceased. The question is whether by the unlawful and voluntary act of the appellant intended to cause grievous bodily harm, or knew that death was the natural and probable result. By the preparation that preceded the act of the appellant, that is, locking the door, before the blow to the head of the deceased with a cutlass, the appellant intended to cause the death of the deceased. I resolve this issue against the appellant. Consequently, this appeal is dismissed.
Welcome back. You would see from the case that both the actus reus and mens rea were present. Otherwise, the court would have set him free, depending on the circumstances of the case. Crime, in whatever form or kind, is bad. Please desist from it. Bye. See you soon.